So we all have to think about who is going to be drafting these orders, because those folks are really going to need to sit down, probably as a team, and go through some of these slides. So what does this 904 cover with respect to this special domestic violence criminal jurisdiction, and particularly over non-Indians? It's going to cover domestic violence or dating violence, and that's going to be defined by VAWA here in just a few minutes, but it also is going to be defined by your tribal codes. So you're going to have to get those codes kind of side by side to make sure that you're touching all of the elements necessary. And it will also, the VAWA 904 will also cover violations of a protection order, note, that are violated in the Indian country of the participating tribe. Now, what amounts to a violation is really going to be driven by tribal law. So again, you're going to have to get that tribal code out and highlight those sections. Can we switch to the next slide? Okay, we said that VAWA 904 will cover dating and domestic violence. So here are the definitions, the VAWA definitions of what dating violence and domestic violence is. So you can kind of look through there. I've tried to highlight the elements. And as we move through this presentation today, I want you all to be thinking about evidence, because I don't think that it's going to be best practices to go in and get a protection order without making sure that each one of these elements that are relevant are proven. And they can be proven in a variety of different ways, depending on whether the action's contested or not. If it's an ex parte or an uncontested protection order, you might just have the sworn testimony of the victim, and the judge may say that's sufficient to make these findings, that indeed this is a spouse or an intimate partner, that they may or may not share a child together, or a person who has cohabitated. But you're going to have to start thinking about this as far back as the affidavits and the testimony that first go before the court. Can we move to the next slide, please? And what a protection order is really hasn't changed. You can read through that, but I want you to see what I've highlighted there, because I'm thinking with my judge hat on that I'm going to make sure that the protection orders that I issue are going to say this order is being issued for the purpose of preventing violent or threatening acts or harassment. I'm going to use those words and put those in the protection order form, or at least suggest that they be put in there. For those of you who are using forms, I'm going to highlight, bold, and underline this. You have to go back and revisit the forms. The forms are okay, but you may have to make additional findings in there and make sure you get evidence on the record. Okay, can we go to the next slide? Okay, when we're talking about 904 again, the Special Domestic Violence Criminal Jurisdiction, we're talking about, let me close my box up here real quick. If I get cut off, it's my fault. Oh, sorry. Okay. It applies only if a violation of the protection order meets these criteria. There's the same phrase we saw on the last slide, was issued against the defendant, is enforceable by the participating tribe, and is consistent with full faith and credit of VAWA. And we're going to go over that in just a few minutes. But I want you to look at the first 3 bullet points. Easy enough to put that first bullet point in the form. You must indicate in the order that notice, opportunity to be heard was given to the defendant that was consistent with tribal law. So you're going to have to really, again, pay very close attention. I would suggest you put statute numbers in there. And again, judges, I reach out to you and attorneys to indicate that putting things on the record, you can never get too much on the record, too much evidence. You go until the judge tells you to stop, I guess. So you need to make sure that the protection order issued has followed tribal law. to the letter, as well as keeping 904 and this language, this very first bullet point, in mind as well. Can we move to the next? Okay, what VAWA 2013-904 does not cover? If the victim and defendant are both non-Indian, not going to cover those. And if the non-Indian defendant lacks sufficient ties to the tribe. Well, what are sufficient ties? Those bullet points set out what VAWA 904 says are sufficient ties. So again, advocates, attorneys, judges in cases where folks are pro se, you're going to have to ask questions about, do you reside in Indian country? The Indian country of the court that's exercising jurisdiction. Are you employed in Indian country? Are you a spouse, an intimate partner, a dating partner who resides in Indian country? So you're going to have to really ask those questions and get those things on the record. I think it would be a really good idea, and I'm thinking that I would really like to do this for my own docket. I'm going to create a check sheet just to make sure that I don't forget to cover. If someone else forgets to bring some of this out, that I can bring this and establish this record. Because this really goes to the heart of being able to exercise jurisdiction over the matter involving non-Indians. Can we go to the next slide? So what do we mean when we talk about full faith and credit? That was on one of the previous slides. VAWA requires certain language to be in the order in order to kick in the full faith and credit provisions of VAWA. And I don't know if we have that language here, if it's on the next slide. But one of the things this slide is telling you, too, is before VAWA 2013, I think jurisdictions were split about whether or not the Violence Against Women Act really clarified a tribal court's authority, their power, to issue protection orders in cases involving non-Indians, and in some cases involving non-member Indians. And there was at least one federal court that said, tribal courts, you don't have the power to do that. So VAWA 2013 really came back and clarified that. And what you need, the questions now I think you need to ask are these. Does the tribal code, number one, and Constitution allow me to exercise jurisdiction over these kinds of cases? And if so, I'm going to show the defendant's ties to the benchmark ties that we went over last slide, and then go ahead and move forward. Can we move to the next slide? I wanted to add the next few slides in here to remind you that due process is a requirement to kick in the full faith and credit clause of VAWA. One of the pieces that I think there are three main things, we could talk about four, that really that you must be mindful of. And again, this language must be in the protection orders, that the court, the tribal court in this case, would have subject matter jurisdiction over the case, and cite to the Constitution or tribal statute that says that the court has jurisdiction over, subject matter jurisdiction over these cases, the power to hear protection orders. The second thing is due process was given to the defendant. Now, all the tribal codes may vary. There's usually notice given to the defendant by whatever way the tribal code says. There's a certain number of days the defendant has to appear in court and put forth the defendant's evidence. So you need to really be thinking about those things, putting that language in the order, and also in cases of cross-protection order petitions, that those have to be filed in writing, and the judge has to make specific findings about why each party needs a protection order according to tribal law. So these slides that we're flicking through right now, we don't necessarily have to go through each and every one of these, but I love this chart. I think it's wonderful, and it really kind of tells you between the Tribal Law and Order Act and VAWA 2013, which of these measures do you have to meet? Which of these benchmarks must be met? So you can kind of just go through the the chart slide slowly, the check marks should come up. And again, this is for criminal, criminal jurisdiction, when the tribal court's trying to exercise criminal jurisdiction. And just keep going. Keep going. I just wanted you to have this as a resource. I just think it's wonderful. Okay, now, protection orders. What is the purpose of the protection order? Multi-purpose. I just listed 3 there. For me, what I think, knowing what I know about domestic violence cases, it sets forth clear commands from the court. Commands that really take some of the power and control away from the batterer. And I have learned the more detailed the order, the more likely the batterer is going to violate it. But you have to be specific. And when you start issuing these protection orders, you really need to start thinking about, will this order stand up as a foundation to a criminal prosecution? Is it specific enough so that the defendant knows what's prohibited? Is it specific enough? And have we served and have we made the record like we needed to? So setting those commands, hopefully all this is done to keep the victim safer. Can we move to the next slide, please? One of the reasons the language is so important, again, will the language in the order kick in the Violence Against Women Act full faith and credit? Many, many victims are mobile. They're crossing over state, tribal, jurisdictional boundaries on a regular basis, sometimes several times every day. And is this order really going to be enforceable when they cross over those jurisdictional lines? So making sure that that VAWA language is in there. Rob is going to talk about what language must be in the protection order to kick in the federal firearms provision. Some of the language is the same, but some of it is different. So really pay close attention when Rob starts talking about the language that has to be present to kick in the federal firearms provision. Thinking about states may use these protection orders as well, especially because some tribes allow for custody to be addressed in protection orders. And so some states will recognize certain language in the protection order and give full faith and credit to the custody provision. So that would be either the Uniform Child Custody Jurisdiction Act or the Uniform Child Custody Jurisdiction Enforcement Act. So if you want to lift that language and put it in the order, it's hopefully strengthening that order. So when jurisdictional boundaries are crossed and the client goes outside of Indian country, the state is going to not only give full faith and credit to the PO, the protection order, but also not question that custody order. Okay, here's the language. I got ahead of myself. The language that really needs to be in the order to kick in the VAWA full faith and credit. There it is. You don't need to change any of it. And again, you know, just be thinking about checking on those forms. Don't reword these things. Rewording, this is taken directly from the federal statute. Rewording can be problematic, as I think Rob may say during her presentation as well. Can we move to the next slide? Thinking ahead to the evidence, and again, I would just reach out to those advocates and attorneys that are litigating these kinds of cases. It's not enough anymore if we're thinking forward to a criminal prosecution that's based on a violation of a protection order, a criminal prosecution of a non-Indian in Indian country. It's not enough just to say the court has subject matter jurisdiction. I mean, we really are going to have to cite the statute. When we talk about personal jurisdiction, we're going to have to meet the tribe's personal jurisdiction statutes, and we're also going to have to tie in the defendant's contacts that we went over earlier on that slide. The defendant's contacts ties to the tribal community. The notice and opportunity to be heard really needs to be specific, such as the defendant was, a summons was issued to the defendant. It was served on the defendant on this day by officer so-and-so. As the court file reflects, the notice clearly states the defendant has 10 days to appear in tribal court. the defendant was served with notice of this hearing for this day, this time, the defendant is not present, or something like that. It's going to have to be that detailed. Don't forget about the relationship. It might be enough for someone to testify, yes, we were married on July 1, 2013. Might be better to get a copy of the marriage certificate. These kinds of things, you know, we have a child together, here's the birth certificate, or if it's cohabitation, I would want some evidence of that. That doesn't mean I'm not going forward with the PO if I don't have the evidence, but I'm just saying start thinking about that now. This has changed. This has changed probably the amount of evidence and the carefulness with which we're going to craft these protection orders. Don't forget to review the elements of the violation or the crime. If you're getting a protection order, don't forget to look at the elements that you're required to prove in the tribal code to get that protection order. Always have those highlighted and make a checklist and check those off as you go through your hearing. Can we move to the next slide? Oh, I couldn't help myself but put in a little pop quiz for you all. Now, hopefully you see where the raise your hand button is. And this, I can't see any of you, so you should relax and let's take this test together. So, go to the next slide. You tell me, if you were the judge, is it enough if you have this in your protection order? I made up a fictitious tribe, the Deer Nation, and it says this court has reviewed the petition for domestic abuse protection order and the motion for temporary protection order. The court has subject matter and personal jurisdiction, and then the court begins to put in its ordered language. So if you will raise your hand, and if you don't want to, I will tell you the answer, but if you could raise your hand just to have a little fun with the technology here, and type in something you think should have been in there that isn't. So what would have made that a more specific order looking forward to VAWA 2013, and you have this order in front of you to see, well, gosh, I'm a prosecutor. I really have to demonstrate that this court, first of all, has subject matter jurisdiction. Is this enough? Is anybody raising their hand?
Yes, Kelly. Donna McNamara has raised her hand. So, Donna, I'm going to unmute your line.
Okay.
Donna?
Hi, Donna.
Hey, Donna.
Come on down.
Hi there.
Hello.
So what am I supposed to do? Am I supposed to talk or type?
No, talk and tell us what you think. What would you have suggested?
Well, based on what you just said, you're going to need to cite in the, I guess it's the second sentence there, it would be better to cite the statutes that give the court subject matter and jurisdiction and personal jurisdiction in this case.
Let me ask you one question. I can't help myself. I want to tease this out. Where would you look to find the statute number?
I would look
in the Deer Nation. In the Deer Nation.
Well, I would look in the Deer Nation's tribal code. Typically at the beginning, at least in the Suquamish code where I work, in the beginning there's a recitation of jurisdiction that talks about territorial jurisdiction and subject matter jurisdiction and personal jurisdiction. I don't know where it might be in other tribal codes.
So if there's a territorial component to your tribal code, you need to make sure that you have evidence on the record that demonstrates that someone resides there, the violence took place there, whatever the code's requiring you to do, you need to make sure now that you get that on the record. You also need to make sure now, I think, to really put on the record whether someone is an Indian or a non-Indian. And then don't forget about the ties the defendant has, that slide. So, very good. Anything else you can think of here? I think that was a great answer, and I think every tribal court is going to be different, and that's the challenge of putting together a slideshow like this, is to keep it very general.
Right.
Okay. Don't forget the relationship. That has to go in there as well.
Kelly, would you like to move on to the next slide?
Please. Yes. Thank you, Donna.
You're welcome.
Thanks, Donna.
Let's take a look at this particular order here. Again, just a little sample for you. The court has jurisdiction to issue the protection order as the parties are married. Again, the judge doesn't have to say what church or what location they were married at and what, but there really needs to be that evidence on the record. They reside within the jurisdiction of the nation. Petitioner's non-Indian, respondent is a member. So you can kind of get the feel for what a really comprehensive paragraph might look like just on subject matter jurisdiction. Okay, can we go down to the next one? The whole purpose of my section was to give you an overview of VAWA 2013, give you some specific tips and examples of issues that will arise when the tribal courts are issuing their protection orders, and to get you thinking ahead. Thinking ahead to this order that I'm asking the judge to issue today. Have I drafted it carefully enough that it can withstand a criminal prosecution of a non-Indian? So be thinking about that. The commands of the court must be specific. The defendant cannot come within so many feet, not just the defendant should not be close enough to frighten the victim. Be very, very specific. Remember that in a criminal case, the burden of proof is beyond a reasonable doubt. So if the defendant can wiggle out of it, and the defendant will have criminal defense attorney. If you leave wiggle room in there, the defendant can move through that. No second chances. It has to be drafted correctly the first time to cover all areas. And I want to just suggest to you all, in this day and age of forms and box checking, don't be afraid to request that the judge add additional information. If your forms are not exactly as you would have them, there's usually a space for other or some spot where you can ask the judge to put specific language in the order. Can we go to the next slide? Okay. Questions and answers for my section, or would you like to move on with Rob's presentation?
I don't have any questions coming in at this point, so we can go ahead with Rob, and if anyone wants to type in questions, you can do that, or raise your hand. I'll make sure to let our panelists know that you have a question.
Okay, thanks everyone, and Donna, thank you again.
Great. Rob, are you ready to talk with us about firearms and protection orders? You may still have yourself on mute. Stand by, everyone, while we're working out our momentary audio difficulties.
Hello, can you hear me now?
Yes, that's great.
Okay, great. I think I was muted. I've been talking away, but now I'll start again. So thank you, everyone, for attending, and I wanted to share some information about firearms and the work you'll do with protection orders in your tribal courts. Just like Kelly said, there's language that's so critical if you are concerned about invoking the federal firearms laws. So we're going to go through that really quickly. I just want to remind you of what's there in terms of domestic violence. Under federal law, persons subject to a qualifying protection order may not possess or purchase firearms or ammunition. So we're going to go through what a qualifying protection order is very soon, but I wanted you to have this citation. You can always put this on the protection order. This can be a standard kind of notification that you provide to anyone who's subject to the protection order so that they know that a federal law, a federal prohibition may apply. They should also know that persons convicted of a misdemeanor crime of domestic violence may not possess or purchase firearms or ammunition, and that's 18 U.S.C. 922 G9. Before that, it was G8, and that's in those cases when there is a violation of the protection order that results in a misdemeanor. Anyone convicted of a felony crime, unless it's something like white-collar crime, insider trading, is going to be prohibited from having a firearm. But in the case of a domestic violence misdemeanor, they will also face this. So if that's the result of a violation of the protection order, this is also a good warning to put on the protection order. Just so you know the structure of how this works for the federal agents, the ATF, the Bureau of Alcohol, Tobacco, and Firearms, enforces the federal firearms law. So they're the ones who are contacted if there is concern that someone is subject to a qualifying protection order or a qualifying misdemeanor crime of domestic violence and that they possess firearms or ammunition or they've tried to purchase them. The ATF is the first place to go for notification. The next is the FBI. They maintain the critical databases that will be used for background checks, and we're going to talk about that more as we go along. But I just want you to see the structure of this. And then the U.S. attorneys are the ones who prosecute those violations. So that gives you an idea of who to reach out to in each of these cases. Next slide. Thank you. So under the protection order prohibition in the federal law, as we said before, it's a federal crime to possess a firearm and or ammunition if subject to a qualifying protection order. And the prohibition lasts for the duration of the protection order. So that means if the protection order is renewed, the prohibition continues. If it's modified in some way, that may affect things. We'll go over the language, and I'll point out places where modifications may affect whether or not the protection order applies. I also want you to note that there's an official use exemption for law enforcement and military personnel under this section of the federal firearms law. So if they're subject to a protection order, they can have firearms while on duty, but when they're off duty, they cannot have personal firearms or work-related firearms or ammunition. So those must be checked in and out with supervisors and left at work when off duty. For the misdemeanor crime of domestic violence, there is no official use exemption. If that applies, it's like the felony prohibition, which means that they simply cannot have firearms while on a job. And if that's the nature of the job, if they must have that, that may affect their employment. Next slide, please. So let's go through what a qualifying protection order is. And I just want to note that we use this word qualifying. That's what the Department of Justice will use when they talk about the protection order and when they're looking at whether or not it should trigger the prohibition. It's not a language that's in the statute, but it's language. This is just letting us know that the protection order has to track the requirements that are in the federal law prohibiting possession or sale of firearms to a person subject to a protection order. So the basic requirements, just a quick overview here, we have to go through relationship, due process, the terms of the order, finding of a credible threat or express prohibition on conduct. Next slide, please. So let's look at the relationship requirement. This is defined in a different part of the Federal Firearms Code, which is 18 U.S.C. 921A32. So someone who is subject to a protection order that protects a party the protected party must be a spouse or former spouse, or must cohabit or have cohabited with the respondent, must have a child in common, be the child of the intimate partner, or be the respondent's child. So any one of these relationships can trigger that prohibition. It does not cover parents. It does not cover dating partners who do not cohabit or don't have a child in common. So just you need to know that that limitation is there. That's something that is a bit of a gap in the law. Next slide, please. Oh, and I'll say, as I went through that, as Kelly noted, that's the kind of thing that must be noted on the protection order. And when we talk about NCIC and the NICS database, they're going to look for that information. So if that information is not provided on the order, if it does not say the relationship between the parties and it doesn't meet one of those that we just saw listed, you're not going to get the federal firearms prohibition to be exercised. The next thing that they look for as they are running this through the databases is the due process requirement. So the order must have been entered after a hearing of which respondent had actual notice and an opportunity to be heard. So what that means is it has to be after the protection order, the full protection order has been issued. So a temporary order does not qualify under federal law to trigger the federal firearms prohibition, because those orders are issued ex parte. And if the respondent is not there, that is not sufficient for the due process requirement in the statute here at 922G8A. So you have to also show that they've had notice. We're going to talk about that later. That in the court record, it is clear that there was notice sent to the respondent, and that there was a court date scheduled, and the respondent knew of that, had been served with the notice. So you need a record of service, and that they had their opportunity to be heard. Opportunity means that if they don't show up, if the respondent does not show up in response to that court order and a default judgment is issued, that's sufficient under this. So while you can't get it for a temporary order that's done in an ex parte mode, you can do this for a default order, so long as we can prove in the record that that information is in there, that notice was sent to the respondent, and the respondent received that service. Next slide, please. So this is the other thing that is so critically important. The language that's used in the protection order has to track what the statute and what the regulations that are promulgated around the statute require. So I always call these magic words, but they really do have to be in there. And you have them here on this slide so that you can actually track this language. You can use this on the protection orders. So you have to have one from column A, basically, and one from column B. You can have all four if you want to, but you have to have at least one from each column. So you either have to have that the respondent is ordered to refrain from harassing, stalking, or threatening an intimate partner or the intimate partner's child. And notice that language, harassing, stalking, or threatening. Those words should be used exactly. Or there's an order to refrain from engaging in other conduct that would place an intimate partner in reasonable fear of bodily injury to the petitioner or the child. So they can be ordered to refrain from the harassing, stalking, or threatening, which is the non-contact acts that would trigger this prohibition, or they can be ordered to refrain from engaging in acts or conduct that really qualify as battery or assault under your code. That's how you would see that. Then you need to choose one from column B. That needs to also be on that protection order for this to trigger the federal firearms prohibition. So there has to be a finding of a credible threat to the physical safety of the petitioner or the child, of the petitioner or of the respondent. So what you list there, you actually make that finding. The court finds that the respondent threatened or beat up the respondent, attack the respondent in some way. You can say any kind of offensive conduct that would fall under the battery statute or the assault statute. That language can appear here. You also can have, what you don't have here is something that would fall down to the level of, say, disorderly conduct. So someone who's yelling or pounding on the door, unless they're making the threat at the same time, saying, you're making a finding showing that they're pounding on the door saying, I'm going to break in and really hurt you, or I'm going to break in and kill you, it may not be sufficient. So you have to sort of be very careful about the language you put in here if you want those protections available to the victim. There can also be, as an alternative, express prohibition on conduct. So you may not make a finding that something has actually happened that meets that level of battery or assault, but you can also have an express prohibition. So it can say future prohibition against it, that the order can say in the future, as of the time of the issuance of this order, the respondent cannot use, attempt to use, or threaten the use of physical force against the petitioner or their child, or they're prohibited from doing any conduct that would reasonably be expected to cause bodily injury. So again, if you need help with this language, the ATF website has some really good examples of that, and if you need, we're going to have our emails at the end, and if you want more examples, we can provide some to you. Next slide, please. Here's an example of a protection order, and you'll notice that it has a lot of boxes that are checked, but the firearms piece is actually written out, and I'm going to highlight that for you. If you can tap it again, Natasha or Chia, whoever's doing this, so that we can raise up the animation on that. If you tap it again, the system might not allow it. I don't know. Try forwarding the slide again and see if it raises it. The highlighted area that I was trying to show you is down toward just below that black redaction towards the bottom. And it says, defendant shall not threaten or harass plaintiff and shall not possess a firearm. He may possess a firearm for hunting purposes only outside of Cumberland County. So that's an example of how you address what to do with the firearms issue on the local level. Most protection order codes will allow any, the court to be, there it goes, now you can see it much more clearly, will allow the court to, in the catch-all provision, to provide anything else that's needed for the safety of the petitioner. And so this is a good place to put in that firearms prohibition. And it's good to put it in there so in case at some point you do need federal actors like the ATF to come in or the U.S. Attorney's Office, there's some information here relating to the existence of firearms and what the terms of that were in the protection order. Next slide, please.
Rob, before we go on to the next slide, Judge Gorchowski has a question.
Sure.
Judge Gorchowski, I'm going to unmute your line, and we should be able to hear you now.
Hello, Judge. I'm not hearing very clearly.
Oh, sorry. Yeah, Judge, it doesn't sound like your connection's good. If you want to type in your question, I can ask that. Sorry about that, Judge.
All right, we can go to the next slide while we're waiting for the question to come in. Just whenever it's there, let me know. Another thing to note is that in criminal cases, sometimes restraining orders are issued if somebody's being released on their personal recognizance or on bail or on bond. And in that case, a restraining order may be issued that says, and do not approach, the victim, the alleged victim, and do not, and you may not come within a certain number of feet. You may not, carry out a certain kind of conduct. Those can be considered under federal law. Those are equivalent to a civil protection order. So as long as they meet those requirements that we just talked about, they too will work under G8 if there's a need to have a federal intervention around firearms. And it doesn't matter if they have a specific gun prohibition or not. As long as that relationship requirement, the due process requirement, and that the findings of fact or the express prohibitions and the orders to refrain are in there that we've just gone through, that will be sufficient. Next slide, please. Do we have the judge's question yet?
I think it was just a connection question, and she's good. Thanks.
Okay, good, great. All right, so, how does this play out? What are the roles of the federal actors and the tribes in doing this? And so I just want to lay that out as simply as I can here. The federal authorities are the ones who determine, by looking at the federal firearms statutes and looking at the protection orders that are before them, whether a protection order or a misdemeanor conviction will disqualify a person from possessing a firearm under federal law. So that determination, this is not a determination that the tribal judge has to make, but the role of the tribal judge is really important because they are the ones who make the findings and enter those orders to refrain from certain conduct or to prohibit certain conduct in the future that are crucial to triggering the federal firearms laws. So if we don't put that information in those protection orders in cases where we are concerned about escalating violence and possibly firearms violence, it is impossible for the federal authorities to be able to do their job and step in if needed. Next slide, please. So now all that information, what do we do with it that was in the protection order that we said we had to have? We have to put it in the National Crime Information Center, NCIC, which I know is a continuing problem for tribes. But quickly I'll just summarize what it is. It's the computerized index of criminal justice information, criminal record history information, fugitives, stolen properties, missing persons, and it has a section on protection orders, a special protection order piece that is accessed by the National Instant Criminal Background Check System. NCIC is operational 24 hours a day, 365 days a year, and law enforcement are usually the professionals who have access to it. Next slide, please. So the purpose for protection orders is to, number one, for full faith and credit, it helps other jurisdictions understand whether or not there's a protection order and whether or not it's valid. If it's in NCIC and it's been entered and it has the right data in it, that will, if somebody leaves the tribal jurisdiction, a state may be able to check that. That's why it's so important that we continue fighting for the tribes to get access to NCIC. It supports the identification of persons prohibited by state and federal laws from purchasing a firearm, and we have to push for the tribal laws to be included there too, so that we can identify persons who are prohibited under tribal law from being prohibited from purchasing a firearm or possessing it. And it also maintains a history of cleared and expired protection orders for 5 years. So if there's a need to look for that history, perhaps in another jurisdiction, NCIC would be the place to look. Next slide, please. For tribal courts, Section 905A of the Violence Against Women Act of 2005 authorized tribes to access and input information into NCIC in cases of domestic violence, dating violence, sexual assault, and stalking. That has not rolled out as hoped, and there's a lot of advocacy here in D.C. to make sure that that really happens, and it will be critical to the tribal courts doing work around full faith and credit, giving full faith and credit to protection orders from fellow tribes, and also ensuring that states can see and recognize and be sure that that there is a tribal protection order in cases where they may enter into state jurisdiction. The things that are needed that really have to be established are T1 data lines, so that that's the needed connection to carry that kind of data. There's training that's needed. The tribal law enforcement agencies that would manage the upload of the data need to be certified by the Department of Justice. So all of this is if you are concerned about this in your tribe as you're developing these processes, you should be working with DOJ to ensure that you have access to NCIC. And I am hoping that at some point very soon there will be sufficient funding to be able to really roll this out properly. Next slide, please.
Rob, before we transition to the next slide, could you do you have further information on what a T1 data line is?
It's one that carries a certain load of data. It does it quickly. You know, you have to just sort of. I can't give you the technical specifications right now, but it's like the difference between that old dial-up that people used to use to deliver data and how slow it was. T1 just does it very, very quickly so that a lot of data can be shifted back and forth, and you can really, these are large databases, and you need to be able to access, you know, records in them relatively quickly. So it just gives you that capacity to be able to do this. And there are DSL lines that can do this also. You know, technology is constantly improving, but you want something at least at the level of, you know, that technology. So the data elements that are collected in the National Crime Information Center, I'm giving you this chart because, again, like Kelly said before, it's really good to have this chart as a reference point. These are the things that NCIC is essentially recording so that other jurisdictions can look it up, so that the firearms background check system can look for this information. So some of it is provided by the by DOJ. Some of it's provided by the tribal court. So once the courts are certified, once your law enforcement is certified to enter information into NCIC, you'll have an originating agency identifier. And that's a number that you'll have along with the terminal that you use to enter the data. These are secure terminals that are limited to pretty much law enforcement access. And you will need that so that they know which tribe is entering the data. What's important that you provide is the subject's name. That's critical. And to the extent that you can provide as much of the name, if there's a middle name, that's really helpful. There are a lot of names that can, you know, that will have twins or triplets or more than that repeated in the database. So the other thing you'll see highlighted in red is a numeric identifier. There are two that NCIC looks for, either the date of birth or the Social Security number, because either of those paired with the subject's name will help them identify a specific record as opposed to pulling up several. So if you're looking up a record for John Smith, you may get a lot of hits, but by putting in at least one of the numeric identifiers, you probably reduce it to one or perhaps two. If you have both numeric identifiers, then you can get an actual accurate hit within the database. So to the extent that you can get the date of birth and the Social Security number entered on the protection order along with the subject's full name, the respondent's full name, and you can get this into NCIC, you make it that much easier for other tribes and states to do their work under full faith and credit, and also to do the federal firearms work. The subject's sex is also helpful in case there's a name that may be ambiguous. The subject's race. There you can put the protection order number or the case number as you do that. The date of issue and date of expiration is very important, because if somebody's looking in there, they want to know if the order is still in effect. So that's important. This is before I had talked about if you modify an order or if you renew it, you need to update this information so that they know, because if you leave the original expiration date in there and let's say it's renewed for another 2 years, if you don't update that in NCIC, they won't know that that qualifying order continues to apply. There's a way of identifying the court in the system. There's a Brady record indicator, and that we'll talk about that later. There may be miscellaneous information that you also include. The training helps law enforcement figure that out. And then the conditions within the protection order. This is important for the federal firearms statute. So that's the place where you want to know that you have either checked the box that says that they must refrain from that conduct, or that you have prohibited certain conduct, or that you've made a finding that they've committed certain acts that match what the statute uses to determine prohibition. That needs to be in there also, or the firearms prohibition will not apply. Next slide, please.
Rob, before we transition to that, Judge Stoner notes that tribes should consider putting an NCIC box on their protection orders so that the info is readily accessible to load into NCIC.
That's a very good idea. It's an excellent idea. And what you can do is, as you look at this chart and you see the things that the court can obviously provide, to put all those together in one box, as Judge Stoner suggested, on the protection order to remind everyone to fill all those pieces out is really, really helpful. And so if you do have someone who is very dangerous and you really do need to invoke those federal firearms prohibitions, that will make the job that much easier. So there's some practices that we have to coordinate to make sure that all of this works. And service is one of them. So when the court issues that order or that date for a hearing, the court also needs to be sure that they send out that notice of when the hearing will be, at what time the respondent is expected to show up, and something that will allow, something that will provide a receipt to show that service has been attempted or that it's been successfully done. At the same time that you're doing this, we want you to note that sometimes this is really the first time that the respondent is understanding that the victim, the petitioner, is seeking help and speaking about what's been going on, and so it can be very, very, very dangerous time for the petitioner. So it may be important also for the court to note when they ask for those orders and those hearing notices to be served, that the local law enforcement who does that makes provision for the safety for the victim by watching out to see if they're around, to give them contact information. In some counties, for example, after they do service of that order, they'll come back the next day just to make sure everything's okay. If it's possible to do that, it's highly recommended. Another practice that's really important is to designate the entering agency. You have to choose who's going to do that, and you really actually even have to identify who within the agency is going to do it, so that you know that this will result in promptly entered data from original orders, and that that person also is responsible for updating orders if they're modified. So the court has to coordinate. The likely entering agency is going to be law enforcement. So the court, if they're modifying an order or issuing an order in the first place, needs to make sure that gets to the right person who's been designated at the law enforcement agency that has the training and certification to enter this information in NCIC. This is important both for full faith and credit enforcement of protection orders and also for the firearms protections. On the protective order forms, standardized statewide forms have turned out to be very, very successful. So we recommend that you make sure that every judge uses, in your tribal court, uses the same order. You'll see check boxes. You can use those to make things more standardized. You can make sure that as I called them before, the magic words appear on that, the front of the protection order. There's a passport page. That is a cover sheet that looks just like every other cover sheet that's issued in any protection order case in the United States. So what we try to do is make sure that all the states and the tribes have that basic information that we talked about all throughout here right on the cover sheet so that if somebody's looking at that order, law enforcement in another jurisdiction, or if one appears in your court, you can look at it and you know the date of issuance of the order, the date of expiration, the names, and that unique numeric identifiers of the parties. You only need the unique identifier for the respondent, but the full names of both parties, the relationship, and any of those magic words that we were talking about, including subject matter jurisdiction, personal jurisdiction. You also want to put those firearms prohibitions on the forms. Before, you saw that language that said under, 18 U.S.C. 922 G8, a person subject to a qualifying protection order is not able to purchase or possess firearms or ammunition. Same thing for the misdemeanor crime. That can be printed on your protection orders. And DOJ does have that sample passport page, which has all that recommended language on it, including the firearms prohibitions. And the court can also have a stamp or some regular checkbox for firearms prohibitions, so that if you don't want to have to write it out every time, again, you can have that specialized area where you can check that off. Next slide, please. The Brady Act is what created the NICS database, which is the National Instant Criminal Background Check System, and basically it applies to all federally licensed gun dealers. They have to do a criminal background check to determine if the purchaser is disqualified because of a qualifying protection order or a qualifying misdemeanor conviction for domestic violence. And so the FBI search can only happen within 3 business days. If they don't get an answer back, then the sale is allowed to proceed by default. Next slide, please. And the system is established and run by DOJ so that they can contact this database by telephone or other electronic means to get that information at the point of sale, at the time of sale. And the hope is that it's instant, as the name says, although sometimes what happens is they are missing some of that information that we talked about before, some of those data elements that are so important, and they may not have a unique numeric identifier, so they're going to be reaching back to the originating jurisdiction to fill in the blanks to see if that's true. That's why the 3 days exists. So that means you also need to have a designated person in your tribal court who can be contacted, and what you'll see on the Project Passport page that DOJ can provide, that unique cover sheet that everybody has across the country that has the basic information on it. You should also have the name of a clerk in the court or someone else who can be reached and when they can be reached during business hours or 24/7, and the number to call, so that if they're having trouble because they're missing a data element to complete the background check, they can call in and check on that. So that's really critical. It's also critical to have that for full faith and credit in case there's a question about the validity or the currency of the protection order. And the role of law enforcement seizing firearms for federal prosecution, generally there's only case law on state law enforcement. There's nothing on tribal law enforcement, but I would imagine that you can have a parallel here, which is that unless the jurisdiction, the tribal jurisdiction, has their own statute that says our laws mirror the federal laws. So if somebody is subject to a qualifying protection order, we're going to seize it on the state level, or unless the law enforcement officers are cross-deputized, which is something that you can also talk to the ATF about. And if you do think that there are firearms that are possessed in violation of federal law, you have to reach out to the U.S. Attorney's Office or the ATF. And it's best to establish that relationship now rather than when you have a really dangerous case, so that they know when you're calling that you will be calling because you really need that help immediately, and they know who you are. Next slide, please. This is just a reminder of the laws that you have. I had my little quiz just like Judge Stoner did. Whether firearms should be seized and returned should be governed by the federal laws and your tribal laws. So I don't know how well the hand system is working or our ability to talk, but do any of you have currently laws in your tribal jurisdictions that allow you to seize the firearms of a domestic violence misdemeanant or someone who's subject to a protection order?
I'm looking for hands. I don't see any at this point.
And if you don't, I mean, if we're not seeing hands because you don't have that, that is something you can consider establishing in your code. Because there may be times when you really want to be able to do that and you do not want to wait for the federal agents to show up to be able to do that. So it is also good to have parallel systems that work in the same way on your tribal level. Next slide, please. And this is just really good practice, that guns should not be returned to the person who is prohibited from possessing them under any applicable federal, state, or tribal laws, or if the firearms themselves are illegal. So if someone has reason to know that the person should not have firearms, but they haven't necessarily seen the qualifying protection order, or they don't know if the feds have determined that yet, if you really have good reason to know, you may not return it until you get that final answer. Because, and the firearms, if they are themselves illegal, meaning that they're contraband, meaning that they were purchased in some way that is against tribal law or federal law, then they can be seized as contraband and held. But if there's a concern that the person possessing them is subject to the federal protection order prohibition or the misdemeanor crime of domestic violence conviction prohibition, the court may want to hold on to those order the law enforcement to hold on to the firearms until it can be finally settled. And ideally, if you have a return procedure, that's the best. So you'd have a court hearing to determine if the protection order has expired, or if some terms of the protection order have changed, so it no longer says anti-violence, for example, it just says stay away, and a stay away provision alone without those other ones about the credible threat of violence or refraining from violent conduct. If it's changed to that, then you may say, okay, the protection order has changed to the extent that somebody's firearms can be returned to them. The court should be doing that through a hearing process. Next slide, please. So here are things that law enforcement should be thinking about to work in coordination with the court. So law enforcement should be able to enforce the firearms prohibitions that are issued in a local protection order. You either may have local tribal law that will allow that to happen, or the court may order it in a protection order. The court may say that local law enforcement is required to go out and seize the firearms and ammunition once the protection order goes into effect, and hold it until the protection order expires. There's also, you need to have clarity in terms of your procedures or your code about whether or not, if the court just says abuser cannot have firearms, but does not direct law enforcement to enforce that, do you have laws that allow law enforcement to search the abuser's residence for firearms? What standard do they need to follow if they don't have a direct court order? Another thing for you to consider is how law enforcement can ensure that the victim will be safe when law enforcement conducts a firearms search or seizure. I'm sure any of you on the phone who are on this webinar who are law enforcement know how dangerous it can be at times when you really have this kind of intervention happening in a domestic violence case. So law enforcement also needs to do their own safety planning about getting knowledge of what kind of firearms are there, making sure the victim and the children are safely away at the time when the firearms are seized according to court order or according to tribal code, and how to make sure that there can be a safe return for the victim and children. And also, you have to make sure that your jurisdiction has an official use exemption policy, so that if any law enforcement officer is subject to a protection order that is qualifying, how will you make sure that they are not taking their service revolvers or their service ammunition home with them or outside of their work, and how, if they're on duty, they're not going to have that there's some way of ensuring that they are being watched so that nothing bad can happen when they're carrying their service weapons. Next slide, please. So here are some of the issues that when we have discussions about this, that tribes have concerns about, and rightly so. When you take firearms away in a protection order, even though this is federal law, there are treaty rights which may have to be considered as to whether or not you do this through the federal process or through the tribal process. You may want to consider subsistence hunting. If it's necessary, then limiting access to firearms, except at times when the respondent is engaged in subsistence activities that involve firearms, and that person is, in the company of someone who can sort of guarantee their behavior while they have that firearm. There's also there's a long history in both the states and in the tribes of keeping firearms for protection of the community and self-defense. There are also ceremonial uses, and the tribal official use exemption will not apply, the one that's under federal law, unless tribal law enforcement is cross-deputized and acting in that capacity. So to work in coordination with federal law, there will be a number of reasons for cross-deputizing tribal law enforcement with federal law enforcement. It's good for full faith and credit. It's good for entering data into NCIC and being certified, and it's also good for the official use exemption under the federal law. Next slide, please. And then just some, this is what Judge Aycock was going to present on, and unfortunately he's ill today and was not able to do it. I'll just go through this quickly, and I think in the next webinar he may be able to do this in more detail. So every jurisdiction is both an enforcing and issuing jurisdiction. So the issuing jurisdiction under federal law, under the full faith and credit provision of the Violence Against Women Act, is that the jurisdiction that issues orders that will be carried to other jurisdictions may have to count on other jurisdictions to enforce them if they travel across those jurisdictional lines. So because of that, the issuing court should be very careful and issue clear orders to facilitate enforcement. So instead of saying something like, parties can share custody of the children and work it out by phone every week, if somebody's in a different jurisdiction, that may be very hard for the other jurisdiction to figure out whether it's happened. It may be better to actually say something like, respondent has custody of the children on Saturdays from 9 a.m. to 3 p.m. And then that makes it much easier for the enforcing jurisdiction that's not totally aware of what the law in the issuing jurisdiction is. The enforcing jurisdiction determines whether the order was violated under the law of the issuing jurisdiction. So what this means is, for example, if your jurisdiction only issues protection orders to people who have been married or living together or have a child in common and doesn't do it for dating relationships, and another jurisdiction does recognize dating relationships, if you were enforcing, the issuing jurisdiction may say, these people have been in a dating relationship, there has been abuse, we make findings, and that the respondent is ordered to stay away from, not to commit violence against that partner. If they go into a jurisdiction where dating relationships aren't covered, that jurisdiction still has to enforce it because they are doing it according to the law of the issuing jurisdiction that issued the order. But for enforcement, they use their mechanism. So if a violation of a protection order in one tribe is contempt of court, and in another it turns into a misdemeanor crime, wherever it's enforced, they will use that mechanism. So if it's treated as contempt in one jurisdiction and an out-of-state order comes in, there's a violation, they will treat it as contempt, even if in the issuing jurisdiction it would have resulted in a misdemeanor conviction. I know that we're going through this very quickly, but I think this will be addressed in more detail in the next webinar. Next slide, please. So the issuing jurisdiction determines who the order protects, the terms and the conditions of the order, and the duration of the order. Next slide. And the enforcing jurisdiction determines how the order is enforced, whether it's contempt of court or treated as a crime. The arrest authority of responding law enforcement, how detention and notification procedures will roll out, and what the penalties and sanctions for violations are. And I think that may be it. Let's go to maybe the final slide after this. Yes, it is. So if there are any questions, we are prepared to take those right now.
I am looking for any. I don't see any hands raised or text messages coming through. We're giving you a few more moments to do that, to ask questions of Judge Stoner and Rob Valente. I would like to, if you have questions or follow-up questions regarding protection orders, please email in anderson@nca.org, as you see on the screen right now, so we can get an idea of what you would like us to focus on for the second part of the webinar series, whether that's the project passport or talking about enforcement mechanisms or other things like that, because we definitely want to tailor the rest of the series to the specific issues that tribal courts are experiencing or having coming up in VAWA implementation planning. And it looks like our audience is pretty quiet today. So I'm going to take the opportunity to thank Rob Valente and Kelly Stoner for being our panelists today. We really appreciate your time. And is there any final points either of you would like to make?
Just that we are both available also if anyone needs any more clarification on any of the points that we've raised. So contact Natasha through the email that she gave, and we will be happy to, if we haven't explained something in a way that works for you, we can help you.
Great. Thank you, Rob. And I would just add that this webinar was a jumping off point. We want to wade much deeper down into the weeds on protective orders, and we'll be doing that with the rest of the series. Thank you, everyone, for joining us today, and have a great rest of your Tuesday. Thanks, Rob and Kelly.
Thank you.